Welcome to Silence the Stigma. I'm Britney.
And I'm Chelsea. And today's episode is one I've personally been waiting to do since we launched this podcast because it deals with something that makes me genuinely angry and I think should make you angry too.
We're talking about the criminal justice system and medication-assisted treatment. MAT specifically, and what happens when those two things collide, which is often
Bad.
and badly.
Mm-hmm. There's a situation, or here's shit.
We can edit it out.
Yes, please. Here's a situation we want you to understand. Medication for opioid use disorder, methadone, buprenorphine, and naltrexone is FDA approved, evidence-based, and recognized as the standard of care for OUD. It saves lives, reduces overdose deaths and by over 50%. It reduces recidivism and improves every measurable health outcome.
And yet people on this life-saving medication get arrested, go to jail or prison, get put on probation or parole, enter drug court, and are told to stop, taper off. You can't be here on that. The program requires total abstinence, or sometimes nothing at all is said. It's just taken away.
And we want to be very clear about something before we go any further. That is often illegal. Not ambiguous, not a gray area, often flat out illegal.
Federal law is clear. The Department of Justice has been clear on this. Courts across the country have ruled, and it still happens every day to real people who end up in the criminal justice system precisely because of a disease they're trying to treat.
Yep. So today we are going to go through all of it. The law, the violations, what probation officers can and cannot do, what judges can and cannot do, and what jails and prisons are required to provide, what drug courts get wrong, and most importantly, what rights you have and what you can do when those rights are being violated.
This episode is for patients, it's for providers, it's for attorneys and advocates, it's for anyone who has ever been told or watched someone be told that they had to choose between their medication and their compliance with the system.
You don't have to choose, so let's get into it.
Let's start with the landscape. People with opioid use disorder are dramatically overrepresented.
Get it out.
I know, in the criminal justice system, right? So, this isn't a coincidence that, people with opioid use disorder are going to have to face these problems. It is a consequence of decades of policy that treated addiction as a crime rather than a disease.
Correct. We're talking about people who are arrested for possession, for low-level drug crimes and offenses, for crimes driven by the desperation of untreated addiction. Many of them are already in treatment. Many of them are on methadone or bupe. And when they walk through the courthouse door or into that unit or the intake unit, that's it. That's it. You got to cut that part out.
And at that point, the point of system contact, the intake unit, something should happen, and it usually doesn't. The system should recognize that person is receiving medical treatment for a serious medical condition, and we have an obligation to continue that care.
Correct. So instead, what usually happens is the medication is stopped. They sometimes, with a clinical rationale that doesn't hold up. Often with no rationale at all, sometimes against the explicit objection of the person's prescriber. So they're making judgments based on something that doesn't even make sense.
Right. And the consequences of that are not abstract. Let's be specific about what forced discontinuation of MAT does to a person.
First and foremost, withdrawal. Forced withdrawal. Opioid withdrawal is not just uncomfortable. For people with complex medical histories, which many incarcerated people have, it can be medically dangerous. Dehydration, cardiovascular stress, severe psychological distress. In jails and prisons where medical monitoring is inaccurate, and inadequate, it can be life-threatening.
Second, recalibration of tolerance. So when someone stops an opioid, geez, even against their will, right? Even temporary, like a pause of taking medication, Their tolerance drops rapidly. Even so, when they're released, return to using at previous dose, they're at an elevated risk for overdose.
And it's oftentimes fatal.
Yes.
And this is the one that I think should be most disturbing to anyone with a conscience. The period immediately following release from incarceration is one of the highest risk windows for overdose death in the entire addiction trajectory. We know this. The data is unambiguous. People leave jail and prison and die at rates that are shocking.
Yes, research has shown that the risk of overdose death in the first 2 weeks of release is roughly 12 times higher than the general population. 12 times, and forced discontinuation of MAT during incarceration directly contributes to that.
Third, recidivism. MAT reduces recidivism. Full stop. People who remain on medication are more stable, more able to engage with treatment and supervision requirements, more likely to remain employed, more likely to maintain housing. Interrupting treatment interrupts stability.
Right. So what does forcing someone off their medication accomplish? It increases medical risk, increases overdose, increases recidivism, and increases the likelihood a person will cycle back through the system. And it's often illegal. There is no defensible justification for it.
So let's talk about the legal framework, because this is where a lot of people, including people inside the system, are genuinely confused or misinformed. And that confusion can cost lives.
Right. So let's start with the foundation. What is the legal status of opioid use disorder?
So OUD is a recognized disability under the Americans with Disability Act, the ADA. Specifically, people with OUD who are in active treatment are protected from discrimination. The ADA defines disability broadly, and courts have consistently held that people with substance use disorders who are in recovery or in treatment fall within that protection.
And this isn't just a technicality. It has real practical implications for how long the system must treat people on MAT.
Exactly. Title II of the ADA covers state and local government entities. And that means jails, prisons, courts, probation departments, parole boards, drug courts, specialty dockets, all of them. Every government actor in the criminal justice system is subject to the ADA.
Which means they cannot discriminate against people with disabilities, including people with opioid use disorder who are on prescribed medication?
Correct. That's the core principle. And when a correctional facility refuses to provide methadone, or a probation officer tells someone to stop their bupe, or a drug court demands abstinence as a condition of participation, that is, in many cases, disability discrimination. Full stop.
There's also a constitutional dimension to this that we should name clearly, right?
Absolutely. So yes, the 8th Amendment in the Constitution prohibits cruel and unusual punishment. And courts have interpreted this to mean that the incarcerated people have a constitutional right to adequate medical care. The standard comes from the Supreme Court case Estelle versus Gamble, which held that deliberate indifference to serious medical needs constitutes cruel and unusual punishment.
And OUD, particularly when a person is in active treatment, absolutely meets the threshold of a serious medical need.
Correct. Courts in multiple jurisdictions have ruled exactly that. So withholding MAT, an incarcerated person who has prescribed it, who is dependent on it, and who will suffer medically without it, that can constitute deliberate indifference. That is a constitutional violation, not a policy discrimination, a constitutional violation.
The 14th Amendment also matters here. Equal protection and due process. People with disabilities cannot be treated differently by the state without justification. And blanket MAT bans are a classic equal protection problem.
Yep. And then there's the Department of Justice, which has made this one of its civil rights enforcement priorities.
Tell us about what the DOJ has actually done here. Because I think people are surprised to hear how far this has gone.
Yeah. The DOJ has issued formal guidance stating plainly that denying access to medication for OUD is discrimination under the ADA. This isn't an interpretation. This isn't a suggestion. This is a formal federal agency guidance.
And beyond guidance, DOJ has taken enforcement action against jails, against courts, against probation departments, against treatment-linked judicial programs.
Yep. Multiple jurisdictions have entered federal settlement agreements, legally binding agreements with the federal government requiring them to provide MAT during incarceration, screen for OUD at intake, ensure access to community MAT upon release, and train staff on their legal obligations.
So when someone is in jail or courthouse says, we don't do Suboxone here, they may be saying something that has already been ruled unlawful.
Correct. Yep.
And that precedent matters, right?
Yeah, absolutely.
So let's get specific about correctional facilities, jails, and prisons, because violations here are both extremely common and extremely serious.
Definitely. Jails and prisons cannot blanket ban methadone or bupe. They cannot have a policy that says we don't do MAT here. The policy applied to someone with a legitimate prescription and a serious medical need is discriminatory.
Oh. So they cannot enforce medically unnecessary withdrawal?
No.
They cannot require detox as a condition of incarceration?
Correct.
They cannot substitute MAT with a non-equivalent medication?
No.
Especially without a legal or a legitimate medical justification?
Correct.
And they cannot discontinue MAT slowly because the person has been incarcerated.
Correct. Yep. The last one is important. Incarceration is not a medical justification for stopping treatments. Being in jail does not change the medical reality of someone's OUD. It does not change the standard of care.
And yet, how often do we hear about this?
All the time.
Someone gets arrested, goes to intake, and is told, we don't do that here. No taper, no transition plan, no medical coordination, just you're off medication now.
Yeah, all the time. And the person goes through withdrawal in a cell, often without adequate monitoring, sometimes with life-threatening complications, and then they get released at dramatically reduced tolerance. And within days or weeks, some of them die.
There are lawsuits that there have been settlements, there are documented cases, and still this happens.
Yep.
Yeah, that is the reality.
What correctional facilities are required to do is provide medically necessary treatment, which includes MAT for individuals who are prescribed it or who require it for their condition, screen for OUD at intake, ensure continuity of care, provide a transition plan, and connect to community treatment at release.
Yeah, and these aren't aspirational goals. These are actually legal obligations, and facilities fail to meet them at face value significantly, and the legal liability is insane.
Yes.
So legal red flags in correctional facilities settings that you may hear are, we don't provide methadone or Suboxone.
Yeah, you'll have to detox and we'll just monitor you.
Yeah. MAT isn't allowed in this facility.
Yeah, your prescription doesn't transfer here.
We'll give you something for the withdrawal, but not MAT.
Yeah, not good.
Okay, so let's talk about probation and parole, because this is where I personally hear the most complaints from people.
Yes.
And where I think the most misunderstanding of what officers actually have the authority to do.
Okay. So let's be very direct. Probation officers do not have medical authority at all. They are not doctors. They are not nurses. They are not licensed to prescribe, adjust, or discontinue medication. Not at all.
Which means they cannot order someone to stop taking methadone or buprenorphine. They cannot require dose reductions. They cannot mandate abstinence from prescribed MAT. They cannot override a licensed medical provider's treatment plan.
Correct. And they cannot, this one is huge, condition compliance with probation on medication changes. They cannot say you're compliant only if you taper off. They cannot say if you want to stay out of jail, you need to get off your Suboxone.
Yeah, that is medical coercion.
Yeah.
And if it's tied to someone's disability, and their protected medical treatment, it is disability discrimination.
Yes. Now, what can probation officers do? They can verify treatment compliance. They can request documentation from a provider. They can enforce lawful court orders. But those court orders themselves cannot violate disability law. They can communicate concerns about a person's treatment to appropriate parties through proper channels.
Yeah, but here's the line. Medical decisions belong to the prescriber. Not the probation officer, not the parole board, the prescriber, the person with a medical license who is legally and ethically responsible for that patient's care.
Correct. And when a probation officer steps over the line, when they tell someone to stop their medication, when they threaten revocation of if someone doesn't taper, they are acting outside of their authority and potentially exposing the department to significant legal liability.
Yeah, we've heard from people who were told by their PO, I'm going to treat you positive for buprenorphine as an unfavorable screen. Mm-hmm. That is just wrong. And that potentially violates the ADA, violates the DOJ, and just demonstrates a fundamental misunderstanding of what MAT is.
Buprenorphine is in someone's urine who is prescribed bupe is not a dirty screen or unfavorable. It's evidence of compliance with their treatment. The distinction matters enormously, and the failure to understand it causes real harm.
So what probation officers cannot legally do? Order cessation of prescribed methadone or bupe.
They cannot require dose reductions without medical justification.
Right. Condition compliance on stopping or tapering MAT.
Count prescribed MAT as a positive drug screen.
Yeah. Override a licensed medical provider's treatment plan.
Yeah. Or mandate abstinence-only approaches for someone who is prescribed an MOUD.
Oh.
So let's talk about judges. Because the courtroom is a place where people expect to encounter authority, and rightfully so, in many contexts. But there are boundaries on that authority that are absolute.
Yeah, and one of those boundaries is this: judges cannot practice medicine from the bench.
Okay. A judge has extraordinary power in a courtroom. They can determine whether someone goes to jail or goes home. They can impose conditions of supervision. They can grant or deny diversion, but they cannot order a person to discontinue their prescribed medication. They cannot require abstinence from an MAT as a condition of anything. They cannot penalize someone for taking medication that has been prescribed by a licensed provider.
Right. And how often does this happen in drug courts, in diversion programs, in dependency proceedings?
Far too often. We hear about judges telling people, if you want to be in my drug court, you get off Suboxone. If you want reunification with your children, you have to show me you're not on methadone. If you want probation instead of prison, you stop taking your medication.
Yeah, and every one of those statements is potentially illegal. Federal guidance from the DOJ is explicit. MAT is not continued drug use. Penalizing someone for taking prescribed MAT is discrimination under the ADA.
Yes. Courts are also required to provide individualized assessments. You cannot have a blanket policy that excludes people on MAT from any program. You have to look at the individual, their medical needs, their treatment plan, and make an individualized determination.
Yeah, a blanket no MAT policy in a drug court or diversion program is facially discriminatory. It excludes people from services based on their disability. That is a definition of a Title II ADA violation.
And in family courts and dependency proceedings, this is particularly devastating context. Courts cannot use MAT participation as a negative factor in parental fitness determinations. A parent who is on a prescribed buprenorphine and compliant with their treatment program is not using drugs. They are treating a disease. Treating that as a mark against them in custody proceedings is not just cruel, it is illegal and indefensible.
Right. So what courts cannot legally order? Tapering or discontinuing of a prescribed MAT.
Abstinence from MAT is a condition of diversion, probation, or participation.
Penalizing individuals for taking prescribed MOUDs.
Blanket exclusion of MAT participants from programs.
treating prescribed MAT as evidence of noncompliance or continued use.
And using MAT participation is a negative factor in parental fitness cases.
So, drug courts. They were created with good intentions to divert people with addiction out of the traditional criminal justice pipeline and into treatment. And they've helped a lot of people. But they're also one of the most common places of ADA violations related to MAT. And that is deeply uncomfortable thing to say about a program designed to help.
Yeah. The problem is structural. Many drug courts are designed decades ago before MAT was a well-established as it is today. And they embedded abstinence-only philosophies into the protocols. And some of them haven't updated these protocols or won't.
So you end up with a situation where someone is offered drug court as an alternative to incarceration. That sounds like help, right?
Sure.
But the condition of that help is you cannot be on methadone, you cannot be on Suboxone. This program is medication-free.
And that is a choice between two forms of harm. Incarceration on one side, forced discontinuation of life-saving medication on the other. That is not a legitimate choice. That is coercion.
Right. And drugs courts must provide individualized assessments. They cannot have one-size-fits-all. Abstinence rules fit that category. Exclude MAT. They cannot require proof of tapering. They cannot punish participations for positive drug screens caused by prescribed medication.
The DOJ has been very specific about this. Guidance from DOJ, guidance from SAMHSA, and guidance from the Office of National Drug Control Policy. All of them say the same thing. Drug courts must accommodate MAT, period.
Yeah. And there has been progress. Many drug courts have reformed their policies. Many now explicitly welcome and support MAT participants, but many haven't. And the people who end up and the ones that haven't often don't know they have rights. They think they have to choose, and they don't.
If you're in a drug court that is telling you to stop your MAT, that is a red flag. You may have legal recourse. We'll talk about what to do at the end of this episode.
Yay.
Autonomy.
I want to step back for a moment and talk about the principle that underlines all of this, because I think it's important to talk specifically about it. And that principle is medical autonomy.
Medical autonomy
Right.
is the right of a patient working with their licensed provider to make decisions about their own medical care. It is a foundational principle of medical ethics, and it is reflected in law.
Right. So what it means in practice for this context, only a licensed, I'm out of the view of the camera, only a licensed provider can determine what medication is appropriate for a patient. That determination does not become someone else's to make just because the patient is also involved with the criminal justice system.
Criminal justice involvement does not suspend disability rights. It does not suspend medical rights. It does not transform a judge or a probation officer or a jail administrator into a treating physician.
Right. So when the system dictates medication, when a court orders someone off their MAT, when probation officers threaten revocation for taking prescribed meds, the system has crossed into unlawful medical decision-making. It has substituted its own judgment for that licensed clinician, and doing that based on stigma. Because it believes, despite all evidence, contrary to medication, is not real recovery.
Right. So that belief is wrong. It is not supported by science. It is contradicted by decades of research, and it is deadly. Yeah. Court supervised behavior. They do not prescribe treatment. Probation officers monitor compliance with legal obligations. They do not manage medical care. Jail administrators maintain custody. They do not determine clinical protocols. Each of these roles has a lane. Medical care has its own lane. And when those lanes are crossed, real people are harmed. People go into withdrawal in jail cells. People are released without their medication and die within days. Families lose parents. Children grow up without a mother or father because a judge thought he knew better than a doctor. Right.
And that is the cost of this. This is what is at stake every time someone in the system decides they have the authority to override a medical decision. They don't. The law says they don't, and it's time for the system to act like it. We want to give you a list, concrete, specific statements that are red flags, potential ADA violations, and illegal practices, because sometimes people don't recognize an illegal statement when they hear it. It can sound like authority, it can sound like a rule, and it isn't.
Right, so let's go through them. You can't be on methadone while on probation. So probation officers have no authority over prescribed medication. This statement may constitute disability discrimination.
Right. This jail doesn't do Suboxone, or this jail doesn't do methadone, or this jail doesn't do Suboxone and or methadone. Blanket refusal to provide MAT to someone with a serious medical need may violate the ADA and the 8th Amendment.
Drug court requires total abstinence. Blanket MAT exclusion from drug court programs may violate Title II of the ADA. Individualized assessment is required.
You must taper to be compliant. Tapering is a medical decision made by a prescriber, not a compliance requirement, enforceable by courts or supervision staff.
Or CPS.
Oh, yes. Good one.
Mm-hmm. Yeah. We're treating your buprenorphine as a positive screen, or your methadone as a positive screen. Prescribed MAT in a compliant patient screen is evidence of treatment compliance, not drug use. You want to see that in the screen.
Right. If you want diversion, you have to be medication free. Conditioning access to a diversion program on stopping prescribed MAT may constitute a disability discrimination.
Recovery housing doesn't allow Suboxone or methadone. Recovery housing that bans MAT may violate Fair Housing Act and the ADA.
Yeah. Each of those statements in the right context is a potential rights violation, and the fact that they are said by authority figures, by judges, by probation officers, by correctional staff, doesn't make them legal. It makes them more dangerous.
Because when people with authority like authority figures like judges and the probation officers say something with confidence, people often believe it's a rule. It sounds like it, but it may not be. It may be that person's preference, the facility's unofficial policy, the court's outdated protocol, none of which override federal law.
Right. Okay, let's talk about what you can actually do if you're in this situation. If you're on MAT and you're facing the criminal justice system, or someone you love is, here is what you need to know.
Yep. First, know that your medication is legally protected. It is a reasonable accommodation under the ADA. You have the right to request that accommodation in writing. You have the right to have your prescriber document your medical need.
Second, document everything. If a probation officer tells you to stop your medication, write down the date, what was said, who said it. If a jail refuses your medication, document that too. If a court order requires you something that conflicts with your treatment, get a copy of that order.
Yeah, keep your receipts.
Yes, for real.
Third, get your provider involved. Your prescriber can write a letter documenting the medical necessity of your treatment. That letter matters. It creates a paper trail. It makes it harder for the system to ignore your needs and put your provider on record.
Yes. File a grievance. Every correctional facility, court, and supervision department has a grievance process. Use it. Even if you don't think it will work immediately, use it. The paper trail matters.
Fifth, contact legal aid or a civil rights organization. Organizations like the ACLU, the National Health Law Program, the Legal Action Center, and local legal aid societies have taken on exactly these cases. You do not have to navigate this alone.
Right. If your rights are being systematically violated by a facility, department, or court, you can file a complaint with the DOJ Civil Rights Division. That is how federal settlements get initiated. How is that policy change? That is how policy changes happen. Real complaints from real people drive enforcement.
Yes. Reach out to your local advocacy organizations, your harm reduction networks, like us.
Yay!
Your recovery community organizations. These communities have navigated the system. They know who can help you. They can connect you to people who have been through this and survived it.
Right. You don't have to choose between your medication and your freedom. The law says you don't. And when the system tells you otherwise, that is not the final word.
That's it. Stop it.
Go.
We want to close today with something we think is really important to say out loud. Accountability does not include medical coercion.
Right. Recovery does not require suffering. Sobriety is not defined by the absence of medication. And the decision about what medical treatment someone receives belongs to doctors and patients, not courtrooms, not jail administrators, and not probation officers.
The criminal justice system has enormous power over people's lives. We're not asking it to abandon oversight. We're asking it to stay in its lane. Do the things it is authorized to do and stop doing the things that it is not.
Right. We're asking it to recognize that when it forces someone off their MAT, it is not promoting recovery. It is disrupting treatment. It is endangering life, and it is breaking the law.
There are people alive today because their jail provided MAT. Because their probation officer understood the difference between prescribed medication and drug use. Because a judge listened to the doctor. That is possible. We have seen it, and it is happening in more places every year.
We want it to happen everywhere. And that starts with people understanding their rights, advocates pushing systems to change, and society that is finally willing to say, treating addiction with medicine is not a controversial position. It is just medicine.
Thank you for listening to Silence the Stigma. I'm Chelsea.
I'm Brittany. And if this episode was useful to you, share it with someone in the system who needs to hear it. A patient, a provider, an attorney, a judge.
And if you need help right now, if you're in a situation where your MAT is being threatened, you can reach SAMHSA National Helpline at 1-800-662-4357. They can help you find resources and connect you to support. It's free, it's confidential, it's available 24 hours a day.
And see you next episode.